So this case, Henry and Leighton Admin Services Proprietary Limited, was a case where an employee had been terminated after he'd made complaints to the company about going over budget on a project, and the company allegedly overstating their revenue by $14 billion. In this particular case, Leighton's, a well-known construction company, sought to strike out the application, saying that there were no reasonable prospects of success. So the judge looked at the initial issues of whether the employee had a claim with reasonable prospects of success, turning particularly on the issues of what does a complaint or inquiry in employment mean and what does political opinion mean.
I think it's a very interesting decision. Yes, we have to have some caution. It's not a final decision, it's a response to a strikeout motion, so they're just looking at reasonable prospects of success. But it is just one of a number of decisions which have moved away from the early adverse action cases that focused on limiting what is a workplace right, and the definition of industrial instrument. There were findings that a contractual right is not included. When you focus on that part of the definition that talks about a complaint or inquiry in relation to a person's employment, as a matter of logic, certainly in my opinion, whilst the legislation remains like that, it in fact does include a wide range of things, and that's what's been recognised in
so
this
one
decision.
of the things that the judge picked up on here was the code of conduct, which had obligations that the employee should be honest and act with integrity, and also they should promptly raise any suspected breaches. And I think it's a really interesting use of a policy, a workplace policy, to show that raising an issue which I guess may be thought to be more about the corporation than the employment can actually be considered to fall within employment.
And many companies have such obligations. I mean, there's discussion about whether, and there's been other cases in the work health and safety realm around this where they've talked about obligations versus rights. But the fact remains that it, the definition does talk about obligations, and when you are in a situation where your employment may be terminated if you don't do something in accordance with a policy, to try and say that the exercise of a complaint regarding that is not something linked to your employment, or make exercising a complaint about your employment is really going to be stretching it very far. I mean, as we noted before, the legislation definition of workplace right is very broad, and the courts have taken a while to get to that point, but they seem to be understanding it. Whether the Parliament would like to wants to narrow it, that's a matter for them. But whilst it is what it is, it's very difficult to narrow.
So the court also had to look at political opinion and whether the employee had expressed a political opinion by requesting that or demanding that the company comply with its obligations under the Corporations Act. And the court held that it is a political opinion that a corporation does have to comply with the Corporations Act, and that is its role as a corporate citizen rather than a private citizen, and they had to conduct themselves in society with the Corporations Act.
And it's
compliance.
Potentially hugely broad political opinion. You just have to look at the number of political parties there are. Some of them very specialised interest groups, to put it that way, that you certainly wouldn't want to, I certainly wouldn't want to, on behalf of an employer, run a case saying that's not a political opinion. Because virtually anything could be a political opinion in this day and age.
So ultimately, the judge held that the application shouldn't be knocked out, but now it obviously needs to go on to a full hearing of whether, on the facts, adverse action was actually taken.